property taxes. One of those things that we all love to hate, and yet here we are paying them year after year. You buy a house in the 80s, you're paying maybe $1,000 a year. Your kid inherits it today, now they're paying 12, 15, 20 grand a year or even more. California's property tax system, with all its quirks and carve-outs, is a patchwork of constitutional amendments, revenue codes, Board of Equalization rules, and just enough contradictory county interpretations to keep things nice and confusing. So today, we're going to do a deep dive into one particular strategy that's generated a lot of buzz lately, the Family LLC. Specifically, how a properly structured series of transactions involving an LLC may allow you to pass California real estate to your children without triggering a property tax reassessment. People often think of it as the Family LLC loophole, though we'll talk about why calling it a loophole is maybe a bit too generous and definitely too optimistic. Also, I have talked about this before in my Family LLC video, but today's video is meant to be a little bit more getting into the weeds of it all. You don't have to have watched that other video to understand today's, however. We're going to break down what the strategy is, why people use it, the critical steps and timing, where it can go wrong, and what you should do instead. So grab a drink and a snack, hit the like button, be sure to subscribe for more, and let's dive in. Let's start with some history. Proposition 13, passed in 1978, capped property taxes in California. Properties are assessed based roughly on their value at the time of purchase, and assessments can only go up 2% per year, no matter how high property values actually climb. Proposition 58 came along and said, hey, if a parent wants to transfer property to their kids, let's let them do that without triggering a reassessment. That's been a very handy exemption for folks. Then came Proposition 19, effective February 2021. It gutted Prop 58. Now you only get that parent-to-child exclusion if the property is your primary residence, your child moves into it and claims the homeowner's exemption, and even then, it's capped at $1 million over the assessed value. Rental property, vacation homes, commercial buildings, gone. All reassessed. So now we've got families who've owned rental properties for decades paying $1,000 a year in property taxes, and if they die and the kids inherit the property, boom. Market reassessment. You go from $1,000 to $10,000 or $15,000 in a year. That's not an inconvenience, that's often a forced sale and an increase in rent for anyone living there. Enter the idea of using an LLC to prevent that from happening. Here's the broad strokes of how the Family LLC strategy is supposed to work. First is the setup. Mom and dad form an LLC. They transfer the property into the LLC. They now own 100% of the LLC, and the LLC owns the property. Then, the initial exclusion. That transfer from individuals into their wholly owned LLC does not trigger a reassessment because under Rule 462.180 and Revenue and Tax Code Section 62A2, a transfer where proportional ownership remains the same is excluded from reassessment. Then, gifting ownership. Over time, they start giving membership interests in the LLC to their kids. But, and this is critical, they never transfer more than 50% cumulatively. Why is that? Because per Revenue and Tax Code Section 64D, if original co-owners cumulatively transfer more than 50%, reassessment is triggered. Any and all real property in that LLC will be subject to a 100% reassessment. Finally, a gradual transition. Eventually, the parents and kids each own 50% of the LLC. A second LLC is created. Property is transferred to the new LLC, owned 50-50. Then the parents gift their remaining 50% in the new LLC to the kids. Now, the kids own 100%. At no point did a single person or group gain more than 50% control in one transaction, and at no point did over 50% of the original co-owners transfer their interests. And because all transfers respected the proportional ownership exclusions under Section 62A2 and avoided triggering Section 64C and 64D, there was no exclusion. In plain English, because every time the real property was moved, it was the same owners. They were simply changing how they held title to the property. Again, all this is to avoid a reassessment of the property taxes by never engaging in a transaction that would allow the county assessor to reassess the property. Well, in theory. Now, let's talk about where this goes sideways, because this is where most people get tripped up. First, there's the ownership identity test. Revenue and Taxation Code Section 62A2 is pretty clear. For a transfer into an entity like an LLC to be excluded from reassessment, that proportional ownership must remain the same. So, if you own the house 100% and you transfer it to an LLC that's jointly owned 50-50 with your kid, well, sorry, that's a change in ownership. Second, there's Section 64C. This says that if any person or entity obtains more than 50% of the control in a legal entity, the property held in that entity gets reassessed. So, even if you follow all the steps, but little Johnny ends up with 51% too soon, that's a change in control, and bam, reassessment. Third, Section 64D. This is the one that gets a little wild. If the property was originally excluded under the same proportional ownership rule when it went into the LLC, but then more than 50% of the original co-owner's interest changes hands, that's a reassessment, even if no single person gets control. It's sneaky, and yes, it is enforced. And finally, the step transaction doctrine. This is a court-related concept where if you do a bunch of smaller legal transactions that are all part of a plan to accomplish a bigger goal, like avoiding a property tax reassessment, then the county can say, nope, we see what you did there, collapse the whole thing, and reassess anyway. This is essentially a substance over form argument, which is, even though the way you went about this is technically 100% legal, the effect of it is something that you are not supposed to achieve, and therefore we, as the government, get to say, too bad, we win anyway, pay me the taxes. So you're probably thinking, what's the solution? Well, it's timing. If you try to go from step 1 to 5 in a week, the county assessor is going to say, nice try, and reassess the whole thing. That's why this strategy is best executed over time. At minimum, 1 year in between each step. Ideally, at least 2. The longer you stretch the process out, the better your chances are that the county sees each transfer as a distinct, bona fide event and not part of some larger scheme. That's also why it only really works well when you plan early, well in advance of someone's death. If your parents are in poor health or already passed, this option is pretty much off the table. But let's say you do all the steps correctly. You follow the rules. You wait the time. The transfers are clean. Eventually, you want to move the property out of the LLC or sell it. That's where the county will request a change in ownership statement and ask who owns this LLC and when did those transfers take place. If you fudge the timeline or hide ownership changes, you're in for penalties and back taxes with interest. So yes, there's a real risk in trying to be a bit too clever. So can this strategy work? Yes. Is it bulletproof, however? No. Some counties, like Orange County, have been a little bit more lenient, or at least more consistent in applying these rules. Others, like Los Angeles County, well, let's just say they don't give you the benefit of the doubt, really. The whole thing is a bit of a legal gray area. It's all technically allowed, but it's always under suspicion. And if the assessor thinks you're doing this just to avoid paying property taxes, then they'll bring out the big red reassessment button, and the way it works here is that you are on the hook for the reassessment taxes unless you can prove why not. Essentially, guilty until proven innocent. But let's say you've managed to avoid a reassessment. Great, you've won, right? Well, not so fast. If you gift ownership during your lifetime, you will lose the step-up in basis at death, meaning your kids could owe much more in capital gains taxes when they sell the property later on. A step-up in basis means all that appreciation and value that has occurred during your lifetime while you own the property is no longer subject to a capital gains tax when the kids sell the property. But if you're alive when you give them the property, well, then they will be subject to capital gains taxes on all that appreciation that occurred during your lifetime, as well as any that occurred after you passed away. Thus, this is a strategy that is really useful for a property that we anticipate to appreciate in value, which, come on, it's California real estate, and where we anticipate either never selling the property or not doing so for a very long time, where it's okay if we owe more capital gains tax later because we saved money each year on property taxes up till then. On a side note, I do have another video where I talk about 1031 exchanges and even go so far as to describe the process for a 1031 exchange of a property inside an LLC. So if that's the case, what we could do instead is sell the property from the LLC, 1031 exchange that property for a new one, defer the payment of the capital gains taxes, and keep going from there. But that's a video I'll link in the corner as well as down in the description so you can learn more there. Going further, however, improper gifting can trigger gift tax filing requirements and possibly gift taxes themselves if you're gifting big chunks of value without using your lifetime gift tax exemption. Oh, and let's not forget, now your kids are part owners of an LLC. Welcome to shared management, decision making, tax filing, and conflict resolution. Family dinner just got a lot more complicated. So yes, you might save on property taxes, but only by potentially complicating just about everything else. So should you do it? Well, only if it fits your family's goals, and only with guidance from someone who understands how all the moving pieces, real estate law, estate planning, tax law, and California property rules all fit together. Don't just do it for a tax savings, do it as part of a bigger strategy. Estate planning, legacy building, and maintaining family control over assets. Not only is this the right way to go about it, it's also the best legal way to go about it too. You don't want to look like a deer in the headlights if the county tries to unwind years of careful planning and transactions because the only reason you could think to justify it was to avoid taxes. And for the love of all that is holy, don't DIY this off a Reddit thread or what some guy tells you in a YouTube video. You do it half-baked, you're gonna have a bad time and pay a lot of money for the pleasure of doing so as well. So there you have it. That's the long version of the Family LLC strategy. It's one of those things that may sound pretty straightforward or easy in theory, but turns into a legal circus in practice. Have you heard of this before? Know someone who's thinking about it or already halfway through the road and sweating bullets? Or you have a topic you want me to cover? Let me know down below. Or want to meet me in person? The consultation is free, but they fill up fast, so schedule one using the link below. Like and subscribe for more videos on real estate, estate planning, and trying to outwit the California tax code one loophole at a time. I'm attorney Andrew Bethel, and I'll see you at our next meeting.